Now, Oscar Pistorius will be released into correctional supervision on Friday, but that's not the end of it for him. He still has a sword hanging over his neck in the form of the appeal, the state saying it's going to go ahead with that. So, as I understand it, that will happen in Bloemfontein?
That's correct. At the Supreme Court of Appeal, and I think a date has been fixed in November. We know the heads of argument have been submitted by the state and by the defence, and it's an issue that is dealt with on the papers. The court record would have all been transcribed, so the judges in Bloemfontein will look at it on the documents, including the heads of argument. So it's not a case that you're going to have new evidence presented. If they should up the conviction to one of murder, because that's what the state is arguing, then the sentence can, and in all probability will be re-looked at, and an increased sentence could be imposed. So he could be he could be back in prison. But we don't know yet. I mean, we don't know which way the Supreme Court of Appeal is going to go.
I think many of us were under the impression that Oscar Pistorius would be back in the dock, that there'd be the defense and prosecution arguing their cases before the panel at the Supreme Court of Appeal. Will that not be the case?
Well, obviously they're going to be arguing. It's judges that have to hear it. I'm not sure how many judges are going to be hearing it. And I'm not sure exactly who has been appointed to hear it. The heads of argument are submitted. The judges consider that. Then on the day of the hearing, the heads of argument are dealt with. There's further additional argument. Obviously, Oscar can be in court. Anybody can go and be in the court in Bloemfontein at the Supreme Court of Appeal to hear what's going on. But you won't have witnesses called again. Oscar won't enter the witness box as a potential witness in the defense case. So that evidence has all been presented, both on the issue of the conviction as well as with regard to sentence. So the court has all the evidence. It's merely the lawyers for the state and for the defense highlighting certain things in their heads of argument, not only on the law, but obviously also on the facts. So the court has to look at and determine the issue of dolus eventualis. That has been debated and discussed, whether Judge Masipa was incorrect in convicting Oscar on the facts that there were, 4 shots into a small area, small grouping, into a tiny little toilet, knowing that there was somebody behind the door. Does that on the facts, and I'm really simplifying things now, amount to murder on the basis of either direct intent or dolus eventualis? Did he, in fact, exceed the bounds of self-defense? Should it have been culpable homicide, or should it have been murder intent? So all of those legal aspects will have to be considered. But the facts, are there, and a court has to apply the facts to the law. And one mustn't become mustn't become too complex, I believe. And I believe the case is not a particularly complicated matter based on the facts. So there'll be no evidence presented, no witnesses, but whoever had testified before can go. Oscar can be present. I'm sure he will be. His lawyers, obviously, and the prosecuting team will be there arguing their case.